The second part and the final section in this course deals with intellectual property law. And this applies domestically and internationally. And this is one that is very, very, very important in today's world. It's become so important because many of the things that we buy today are intangible services. And intellectual property is very much an intangible item. It is not physical. It is someone's idea, someone's design, someone's invention. It is not something that you can look at and say, this is something that we can clearly see was made by you. So intellectual property law has become critically important, particularly in the realm of the internet. And as I say, this is chapter 26. So intellectual property is really a subcategory of intangible personal property referred to as ideas, information, and creative works. Intangible personal property refers to the rights or the claims that one person has that has value or can be enforced in the courts, such as the right to collect a debt. These rights are often referred to as chose in action or right to sue. So right off the bat, you're running into some challenges in the court because, again, it is personal property in the form of ideas, information, and creative works. These are often very difficult to point to and say, that is mine. Okay? So, and when you are granted that intellectual property right, the job of the court is to ensure those rights are protected. And it's a very difficult challenge for the court because it is just ideas and information. It's very hard to define who came up with it. So intellectual property law attempts to balance the protection of the product of a person's mental effort on the one side and the free flow of new and innovative ideas that stimulate the advancement of commercial environment on the other. So there's a little bit of a paradox going on. The thing is, our world develops and our whole economy develops really on people coming up with new ideas on how to do things that make us more productive. So you can imagine years ago, I'll just take something, a very tangible thing that people can relate to. Years ago, in order to put paint on a wall, okay, in order to put paint on a wall, you used to have to use a paintbrush, and it took an extreme amount of time and energy to paint. Brushing is very, very slow. It works, and you can do it, but it takes a lot of time. A Canadian inventor came up with the idea of a roller. And this roller would have bristles on it that would hold paint, and you could roll it onto the wall. And it sped up the painting process by about a factor of 5 times. And it did a very good job. True, you still need brushes, but the paint roller brought tremendous efficiency to painting. Now, the thing is that in our society, we'd like the idea of efficiency because we can do more with less. It takes less time to paint a wall. You can paint more walls. Cost of painting the wall goes down. Human effort is reduced. A lot of positives that contribute to the overall wealth of our nation and overall wealth of our economy. So people are going to say, yeah, I want one of those. That's a good idea. Well, at the same time, if we flip around and we say, okay, let's look at the individual who came up with the idea of the paint roller. He or she would certainly want to benefit from their invention. They want to, make sure that they're rewarded for their innovation. And in order to reward them for their innovation, you got to limit the number of people who have access to that paint roller, or make sure that those people who have access to the paint roller pay the person who came up with the idea. So it's a bit of a double-edged sword. We want it to be used and put into place because it encourages efficiencies and it makes our society more efficient and adds value. Well, at the same time, we want to ensure that the person who came up with the idea makes the most on it. So we don't want everybody using it. So we're at this kind of a seesaw between free flow of ideas and compensating innovation. So government and the law has really been wrestling with this idea for many, many years. And legislation has been developed and legal precedent has been developed around this idea of intellectual property, the ideas. So, the paint roller is really a tangible embodiment of the idea. What we're focused on is the idea. Okay, so most legislation protecting intellectual property is federal, while copyright and patent legislation being exclusively granted by the federal government. So the federal government has really taken the reins on this. If you look at the Constitution, 1867, it grants the federal government authority to do this. And this is good because, as you're well aware, the paint roller is used in every single province. So it's not as if we need different legislation in each province. So there are really three major types of, three broad categories of intellectual property out there. There's, as I say, ideas, which encompasses works of art and things like that. And there's physical products that are developed, such as paint rollers. And there's images or logos, these sorts of things, industrial design, we'll call it. So there's a lot of permutations on intellectual property. The very first one we want to deal with is the one that is probably most common, and that is the concept of specific protections for works that are written down. Copyright. The Copyright Act was first brought into place in Canada in 1928 and has been amended lots of times since then. But the fact of the matter is, it has almost 100-year history in Canada. And effectively, what the copyright does is specifically protects computer software. It also protects original works published on the internet. It extends to the authors of written work, or artist in the case of something that is drawn or whatever. It extends protection from the end of the calendar year in which they die for 50 years past that date. So essentially, what copyright does is it makes sure that the author of a work continues to own the rights to that work for up to 50 years after their death. So their estate will really benefit from it. So if you're someone like Drake and you pen a song, that song is protected by copyright. And it will remain protected by copyright until 50 years after the death of Drake. There's no formal registration necessary with copyright. The moment you write something, if you are listening to me now and scribbling on a pad of paper, and that scribble that you have there, that is automatically copyright, meaning it is yours and it is protected as yours for 50 years past the period of your death. There's no need to register it. Now, the question then becomes, well, if I don't register it, who's going to know that I did it? And that is the fundamental problem, isn't it? It's one thing to say that there's no need to register it, but how can you prove it's yours? So you can register a copyright, but you don't have to. But the fact of the matter is, fundamentally with copyright, it is your job to protect your copywritten materials. It's not the government's job. So that scribble that you wrote down, if I took it and copied it and sold it for money, you would have to come after me to stop me from doing that. The government wouldn't be the ones to come after you. So really, copyright is for the beholder of the copyright to ensure that the copyright is kept. So the owner of the copyright controls the reproduction of the work during the period after which the work becomes part of what we call public domain. You'll notice that in church, a lot of the hymns are very, very, very old. And the reason they're very, very old is because they are all in the public domain. They're outside of the 50-year period of the fact of the author's death. And this kind of saves the copyright issue in terms of churches or performances. And this is the thing, you say, well, I can sing a song by Bob Dylan. Bob is very much alive. Am I breaking copyright? In the strict sense, if you're making money on it, you are. It is his song. You're making money on it. You're making money off his work. So theoretically, he should be entitled to a certain portion of your work. Now, the question is Bob Dylan going to come after me for that? Probably not. Now, if I introduced a song and it became wildly popular and I made a lot of money on it, Bob Dylan will probably be after me on it. And Bob would do one of two things. He could either cease and desist, which would stop me from doing it, so the song gets erased, more or less, or he would collect royalties from it, which is the more likely case. The Copyright Act gives the owner of the copyright a monopoly. So effectively, it is a monopoly over the use of the created work, prohibiting copying or reproduction of the work without permission. And only the actual work itself is protected, not the ideas behind the work. So what's covered? There's a lot covered under here. There's literary works, which are literary compilations, such as articles and postings, news feeds, books, computer software, code, and hardware design. Dramatic works, movies, videos, television, theater productions, performances, including choreography and scenery that's fixed in some permanent form, such as writing, including electronic. Musical works, musical compositions with or without words, including music embedded in a website or stored electronically. Artistic works, paintings, drawings, charts, maps, plans, photographs, sculptures, graphic user interfaces, and architecture. In addition to these works, copyright protection has also been extended to performances such as actors, musicians, dancers, singers. Sound recordings such as CDs, tapes, computer memory, and methods for reproducing sounds. And communication signals such as radio, television, cable, and internet broadcasts. All of those are protected by copyright. So it's interesting to see how many things are covered by copyright. Now, as I say to you, that he who owns the copyright's job it is to maintain the copyright. So copyright belongs to the person who created the work or to the employer where the work was created as part of employment, unless there's an agreement otherwise. Now, this is an interesting one. In a lot of places, such as the college or the university or something like that, you look at these courses, for example. The copyright. Who owns the copyright on this class, for example? Okay, so this class is recorded. Who owns the copyright for it? Well, in some organizations, that copyright goes to the individual. In other organizations, it goes to the organization. In the case of the college, in our contract of employment, it clearly says that the college owns the copyright to the classes. In the university's case, the professor owns the copyright. So this provides some interesting problems or challenges for organizations who may have people who are inventive by nature, okay? So let's assume that there was an art class going on by the college, and the artist at the college produces a work of art that's worth millions of dollars. Who gets the money for it? And that the advantage for the institution is that it could be a great source of revenue. However, the disadvantage for the individual is, it's their work, and the college got the benefit because they happen to work there. So all of these are presenting some interesting cases and problems for who owns the rights to the products that you produce at work. So one of the things that your contract of employment should state is, if you're in an inventive type environment, you need to be aware or wary of who gets the copyright for the items that you produce. So once copyright has been created, its owner can assign or license it, all or in part, to someone else, including to a corporation. So oftentimes, like if you look at a lot of the music that's being produced today, what the artist will tend to do will be to move the copyright to a corporation. And the reason of that is that a corporation has an indefinite life, as we've seen, right? So this 50-year rule after the death wouldn't hold. So if the copyright is owned by the corporation, the copyright will be maintained literally forever, or until the organization disappears. The owner of the copyright can assign it to someone else, but even then, the author will continue to have moral rights to the work. So you can sell your copyright, but you still have what's called moral rights. And when we think about moral rights, there are really three moral rights: attribution, integrity, and association. And this allows an artist, author, or performer to demand that, one, her name or pseudonym continue to be associated with the work as the author; the work not be distorted, mutilated, or otherwise changed in such a way to degrade it or bring harm to the reputation; or three, the work not be associated with any products, causes, services, or institutions in a way that may be prejudicial to the author's reputation. Now, where has this happened? Well, if you go back to the Trump campaign and other political campaigns, you will find that several artists have complained. For example, Neil Young, a Canadian artist who lives in the United States, very well known. Some of Neil Young's songs have been used in political advertising, or political rallies, we'll call it, political rallies, by the Trump organization. And Neil Young has gone to that and asked them to stop using his songs in their political functions. And the reason is that he holds moral rights as well as copyright rights, moral rights to those songs, and that he can, under law, he can ask that they not play those songs. Again, it's his job to manage it, though. So copyright can be assigned but moral rights are retained after the assignment. The moral right of association bars the use of work with a product, service, cause, or institution that is prejudicial to the reputation of the author or without the author's permission. So political parties, be warned. Here's an example of Sarah McLachlan, for example, a Canadian artist again. Sarah McLachlan's song, "I Will Remember You," was used in a video that related to the Columbine High School tragedy. And a police force had used it to make a video for some reason or another. And what had happened is that she found out about it, and the video was being sold for $25 each. And she found out about it, and she asked that her song not be associated or not be on that video. So the tape was put together for firefighters training. So the decision to sell the tape followed a court order to make it available to families of victims. Now, okay, so copyright is restrictive. We know that. Okay, and what from a user's point of view, if you wrote something or had a famous piece of artwork or something or another, people like to enjoy it. And sometimes people like to use it for study purposes and the like. And the question is, what does copyright do to prevent you from doing that? Or what can you do with a copyright item? So amendments to the Copyright Act broaden the fair dealing exception, expanding on the right to use copyrighted work under certain conditions. So the general public can use copyrighted work under certain conditions. Education, satire, and parody are allowable fair dealing circumstances such set out in the Copyright Act, as well as research, private study, news reporting, criticism, and review. So you can use Copyright Act, so copyright work, so for example, a quote from a book or whatever, for the purposes of education, satire, parody, and the like. There's no infringement on copyright if the copyrighted work is used for any of these purposes, provided the use also meets the fairness factors established by the court that take into account the purpose, the nature, the amount, the alternatives, and the effect of dealing with the work. In terms of infringement of copyright, infringing copyright includes situations where a person tries to obtain the benefit from the sale, reproduction, distribution, performance, broadcast, or other commercial use of a work. So again, there has to be a benefit going to that person who's using it. Plagiarism, copying another's work and claiming it as your own, is also a violation of copyright. The moral rights of an author are infringed when someone else asserts authorship or the work is mutilated or modified in such a way that the reputation of the author is harmed. And this is a big challenge for a lot of authors or a lot of people who design things. I'll call it artistic works. Okay? Let's assume that you take a picture of an artistic work, the Mona Lisa, say, for example, and you stretch it. You put it on and you stretch it in order to fit the page. In other words, you mutilate it. That would create some very serious problems for the author. I don't know if Leonardo da Vinci is the author. I don't know he'll be too quick to come and sue you on it. But the fact of the matter is, you want to preserve the shape and don't mutilate the work. Regardless of who owns the copyright, where moral rights have been infringed, the author can seek an injunction or compensation. Again, so this moral rights issue comes up. So that's copyright. That's the very first one that we're dealing with. Any question on copyright?
No.
Okay, so the key thing that you want to take from copyright is copyright benefits the author, but it has to strike that balance between benefiting the author and making sure people can use it for their purposes of whatever, being able to read the work, being able to enjoy the work, being able to criticize the work, being able to report on the work, these sorts of things. Another very important component for intellectual property legislation is something called patent legislation. So patents are really a design, it is a protection of a design, okay? So I have a stapler here in front of me, and if I look at that stapler has a mechanism, and I can push down on it, it pushes the little staple out, and the staple binds the papers together. Now, that is a patentable object. In other words, it has some form and function. And patentable items tend to have a form and function that is really the essence of what the patent is covering. So the Patent Act, the Trademarks Act, and the Integrated Circuitry Topography Act are all part of this patent type umbrella. And it gives the rights to the inventor. The inventor has some degree of control over the product. just this past year, Arctic Cat, which is an American manufacturer of snowmobiles. Anyway, Arctic Cat used a design for their snowmobiles that was patented by Bombardier. And in fact, Bombardier took them to court and they were awarded $3 million in damages over the patent infringement. But you think, well, $3 million is not a lot of money when you're talking to these huge corporations. But one of the other things that was in the patent infringement case or the award was that Arctic Cat was no longer allowed to sell those snowmobiles in Canada. And this obviously had big implications for them. And in November, they reached an agreement. So Arctic Cat snowmobiles were again available for sale in Canada, but it certainly did the job on Arctic Cat for a few months anyway. And it created some serious challenges over this. So every once in a while, you see examples of this type of situation happening out there in the marketplace.